So, ladies and gentlemen, this is the continuation of the last class in which we were discussing about artificial intelligence and the nexus between artificial intelligence and intellectual property. And we saw that artificial intelligence is a general purpose technology. General purpose technology means it can be used in anything, theoretically speaking. So previously we had different other general purpose technologies, for example, steam engine, electricity. Now electricity, you know that electricity is in everything is run on electricity. Similarly, computers, semiconductors are everywhere. Anything has been connected with internet. Similarly, artificial intelligence is also a general purpose technology, which means that it can be embedded into anything. And we also saw this comparison between artificial intelligence and other new innovation technologies. We saw that artificial intelligence is pervasive and it improves over time. It is spam innovation. It is fundamentally destructive as compared to some of the other technologies such as blockchain or cryptocurrency or intelligent and connected devices in terms of Internet of Things, quantum computing, clean and sustainable energy, and augmented reality and virtual reality. And we also saw this slide which shows that there are certain areas, for example, in medicine, when it comes to the detection of carcinomas or myelomas or other sort of skin diseases, artificial intelligence embedded systems have already outclassed the human doctors. I mean, they can detect these skin conditions much accurately at a better speed as compared to a human doctor. So today we will discuss intellectual property and the artificial intelligence and intellectual property rights. So first of all, we need to define what is intellectual property. Intellectual property is ideas, information, and knowledge. Intellectual because it is the creative output, and property because it is used as tradable commodity. So we talked about it. That unless your ideas are not in some sort of visible form. In our case, in Uzbekistan, for example, you require to have your patent registered. If you have an idea, you need to put it on the paper, and this paper, you should take it to the agency which registered the intellectual property rights. You will give them, and then they will register your idea. So in this case, we can say that if someone has idea, if someone simply has an idea, it doesn't mean that you can get intellectual property rights unless you get it registered. And when you will get it registered, only then, legally speaking, it will become your property. So what does it mean by intellectual property rights? Intellectual property rights are specific legal rights which protect the owners of intellectual property. So they include patents and copyrights, database rights, design rights, trademarks, and know-how. So all of these things you can get registered with the specified agencies or the patent office, and then you can become the owner of the intellectual property. So in simple words, intellectual property is the output of your intellectual work. It is property because you can use it as a commodity. You can do buying and selling of property. Similarly, you can use the same intellectual work to buy and sell something. And rights, when you will get registration with a state body, then these rights will be assigned to you. So there are different types of intellectual properties. We will see it in the upcoming slides. And how you can protect your product or service. There are different ways. For example, your legal right is patent. So if you have a new innovation, you can get a patent of this new invention. And why you need it? You need it to stop other from making or selling and using this invention. You want full credit of your product, and that's why you will go to the relevant authority and ask them that I have invented something new, and that's why I need to get the registration of my product, and you will get a patent. Similarly, there are trademarks. Trademarks are product identifiers. Product identifiers are specific to a specific product. For example, KFC has a trademark, McDonald's has a trademark, Coca-Cola has a trademark. So when you look at these trademarks or symbols, you can simply realize that this is a specific product, or this product pops up in your mind. So it stops other from using your product names, logos, and jingles. So trademarks are the product identifiers, not the exact product. Then there is registered design. Registered design means external appearance. It is the packing, pattern, colors, decorations, shapes. Yes. So you can get patent for this. And know-how. Know-how means the information which is not publicly available, and it can be licensed to other to generate revenue. And copyrights are original creative and artistic forms. You write an article, you paint something, you draw a photo or picture, you can get copyright of it. It stops other from using writing and literary works, art, photography, films, TV, music, etc. You can get copyrights on it. For example, you have written a poetry book, you can get copyrights of it. You have painted a picture, you can get copyright of it. And then the database rights. This is comparatively new, I would say, form of intellectual property, the databases. So databases can be used for various purposes. Data is new oil. Data is very, uh, useful for many people. They can generate revenue out of it. They can make money out of the data. And we have discussed in our previous classes so many times that how you can generate revenue from the data. So the database is also a kind of product which can give you intellectual property rights. And there are multiple layers of intellectual property rights that can be used simultaneously. For example, a product, the Coca-Cola recipe, you can get patent. Then the bottle is the registered design, then the trademark of Coca-Cola, then the know-how, and there is copyright also, and the database also. So for example, in Coca-Cola's bottle, you can find so many intellectual property rights which Coca-Cola owns. So patents can be used to protect new inventions, prevent unlicensed manufacturers use, importation, and sale. They can choose to let other use under agreed terms. For example, Coca-Cola original company can give some rights to the Coca-Cola Uzbekistan. And similarly, other companies can give the rights to some subsidiary bodies so that they can also generate revenue or make money on the behalf of the parent company. Give breathing space to develop a business based on an invention. So society in general benefits from improved products. It can be licensed before it is granted. And if we talk about some of the drawbacks, formal application required. Sometimes it takes a lot of time to file a patent, and protection can be granted for a limited period, 3 to 5 years, or duration of protection can be 20 years. So full description of invention published after 18 months. And during this period, someone else can file a new invention with the new name, but the same product. Do not confer a legal right to exploit the invention, and geographic dependence, and it is costly. Yes. So these are some of the drawbacks. So what is patentable in pharmaceutical industry? For example, different medicines are patentable. Different medicines are not patentable. For example, life-saving drugs, some of them, they are no longer required to get a patent. Many vaccines, for example, or they are considered as life-saving drugs, and no one can get patent of this. Or there are patents which are for a short duration so that the company can generate some revenue or get the money back which they have spent on inventing this drug. So what is the criteria for patentability? Very basic question for intellectual property rights students, and very informative. So you cannot get patent of anything. There are some criteria which you should fulfill. For example, it should be a novel idea. Novel means it should be new. It shouldn't be made public before application date. It should be new, yes. And inventive. It should be something non-obvious. For example, you cannot say that I have invented a spoon to eat something. Yes, it is obvious that spoon are there to eat something until a specific function is attached to the spoon. For example, spoon for those people who doesn't have their hands, or for blind people, something like this. Yes, but a spoon is an spoon itself is not an inventive thing. Many people know already about this. And then there is applicability. Applicability means your patent should have some sort of commercial application. It should not be just for the sake of entertainment. Your patent should have some sort of commercial benefits. You could make money out of it. And finally, it should be enabling. Enabling means sufficiently describe the invention for others to practice it. So when you file a patent application, you write the description, you make different photographs, different charts, so that the other people can also make by looking at this. So these are the 4 criterias if you want your intellectual property get patented. So you have an idea, you want, or you have made something new, you have invented something new, a new product. Now you want to get patent of your product, you should look into these 4 things. That it is a novel idea. Novel idea means it should be new, it should be inventive, means it should not be obvious. Yes, it should be something new in terms of its use. For example, it should be applicable, which means that you can use it for commercial benefits. And it should be enabling. Enabling means when you will describe it, the other people should understand what it is about. So when you have all of these things into your product, then you can file an application for patent. Yes. So now look at what is a prior art. Prior art is any evidence that your invention is already known in forms of novelty and inventiveness. So this includes anything publicly disclosed about your invention by you or anyone else, or anything that suggests or alludes to something very similar to your invention. So we will say that it is prior art. Or in simple word, if something is known to the public already, then it is something which is called as prior art. I mean, people already know about this. So tools for patent search, these are some of the listings. You can see that the Google has a Google Patents website. You can simply go there and you can type a patent, and you can find if this product has previously been patented or not. And then there are other websites which are paid, for example, PatSnap, Innography, PatBase, which is used for drugs and pharmaceutics, and many others. Yes, you can go on these websites and you can search that your idea is new and genuine and no one has previously registered this. So there are different routes to commercialization. If you want to get your patent registered, you should go through these channels. You have a patent, then you can go for expert consultancy. If it has potential impact, then you can protect it. You can make a prototype, you can market it, and then someone who is interested in this product, he can invest in it. and they can use it for commercial purposes, or maybe a new company can be made based on your idea. So this is how you can do the commercialization. Here I will just give a quick overview of what is going on in terms of artificial intelligence policy in different countries. So artificial intelligence policy in USA, President Trump, apparently, very conservative president, and when it comes to the Obama healthcare bill or similar things, it seemed that they haven't uh, pulled they pulled out funding. But in terms of artificial intelligence, we can see that they have invested a lot of money, like $2 billion, and artificial intelligence, actually America, in terms of bringing novel ideas in terms of artificial intelligence, America is taking lead. Yes, China is giving a tough time, but America is still taking a lead. Yes. So there was a policy, American policy, and American AI initiative, and a lot of money has been spent by the last government. So what is artificial intelligence? We have already discussed how to patent the artificial intelligence. What part of technology are being claimed as invention, because artificial intelligence is, based on artificial neural networks, and which part of these neural networks, for example, they are patentable. This is a debate. Yes. And global perspectives, China, Singapore, and Japan raising the bar for patentability in European Union. So European Union is seriously thinking about raising the bar or threshold, which means that not everything should be patentable. And I will not go into these technical details. Okay. Yes. And finally, once again, from where we began our discussion, comparison between superintelligence and the human. Of course, in future, artificial intelligence will take over, and not only in terms of their speed of work, their quality of work, but also in terms of inventions. And when it will come to the inventions made by artificial intelligence, humans will be like chimpanzees and artificial intelligence will be like Einstein. And I showed you this graph, that on this graph, humans in comparison to artificial intelligence will be like village idiots, and artificial intelligence will fall beyond somewhere on this spectrum. And this is a graph by IEEE, which shows that the exponential growth in terms of human innovations and new inventions. For example, we have achieved artificial narrow intelligence. We are discussing about smart cities. Healthcare is also somehow connected. Yes. And with the passage of time, we are going towards artificial general intelligence. And then there will be a time when we will have human too. And then we will achieve artificial superintelligence. And then there will be space colonization. And then there is a possibility that there will be radical life extension. So let's wait and watch. Maybe we will see some of these achievements in our own life. Thank you very much for the attention.